Hello everyone. So here we are again with the new chapter, inspection, inquiry and investigation. Now this is a very small chapter. However, it has a lot of sections, but the sections are small and they do not involve much of conceptual understanding. Now these are three terms often used as synonyms by us, but here in Companies Act we cannot use it as synonyms, and wherever it is inspection written, it means inspection only. Inspection, inquiry and investigation are three different words used for three different purposes, and they have three different laws according to Companies Act. So first of all, we need to understand what these words mean, although they have not been defined in the Act, and you will never be asked the definition or the meaning of these terms. You will only be asked about the provision. But yet, for better understanding, you must actually know what these terms mean. Now, let's imagine a situation. Let's relate it from our lives that we go on daily. Supposedly, one fine day, or you might not call it a fine day because in my example, you've left your phone at home. So one fine day when you were in a rush, you had to reach the college in time, or you had to meet some friend or whatever. You were in a hurry, and in that haste, what you did is you left your mobile phone at home. Now the moment you left home, your mother came to your room and she picked up your phone. Only that feeling terrifies you, right? That what will she... Your phone is locked. Don't worry at all. Your phone is locked. She will not be able to see anything or get any information. But she just wants to put your phone on charge. Now, when she picks up your phone, there is a call. Someone calls your mobile phone. Okay. And the name displayed there is Honey calling. Honey might be a nickname of one of your friend, but as soon as your mother reads that Honey calling, she gets suspicious of who this Honey is. So suspicion is the root cause of any further inspection, inquiry or investigation. So the first thing that she will do when you come back, she will ask, who is Honey? Maybe as soon as she asks you who is Honey, you start stammering. He, she. You start to say like this. Now her suspicion is getting stronger. Why? Because she is not getting a satisfactory reply. If you confidently say, "Oh, Honey," he is the nickname of Amma and Mama. Supposedly you said something like that and she is satisfied, her suspicion would stop right there and she won't make any further inspection, inquiry, investigation, right? But if she doesn't get a satisfactory reply, or if you don't reply at all, then she will know that there is something which is not really right, or something which is hidden by me. Okay. So she will start inspecting. She called information from you. She wanted information from you. You failed to provide the information which could satisfy her. So now she will go on to maybe to inspect, like she will look into your phone if it is possible. Supposedly you have left your phone unlocked at some point of time. She will immediately look into your phone. She will check for messages, call records, any photos and anything like that. She will go on to see like that. She might make inquiries with your friends. She might inquire with your friends, or if you're going to the tuition, if you're saying at home that I'm going to the tuition or the coaching classes, she might even inquire at your coaching classes. Or she may hire someone to investigate into the whole matter. Ma'am, every word here seems fine. I hope you have understood one basic point, that there is suspicion which gives rise to inspection, inquiry and investigation. So unless there is anything which is not in order, these three terms are not required. So the first thing that is required is some suspicion. How do people grow of suspicion? When there is something which is not consistent. Supposedly I ask a question. There is a very famous joke. I hope you all know that. There were 4 friends and 4 of them were absent. All 4 of them were absent on a day in a school. So the teacher actually called all four of them in college. Let's say, for example, the teacher called all four of them and asked why you four were absent on the same day. All four of you had some fever or something like that. So they said, no ma'am, actually we were on our way, but the tire of our car got punctured. The teacher said, okay. The students were amazed that we have succeeded in actually fooling our teacher, but the teacher called all four of them, made them sit in four different rooms and gave them a test paper. The test paper had just one question which stated which tire got punctured, and all four of them gave four different answers. So when you get different answers, you know that something is not right. When your financial statements say something else, but the report that you have filed says something else. So when there is inconsistency of the information which is present with any authority, the authority grows suspicious of what is happening in the company. And the authority wants to rule out all the suspicion. Why? Because in the benefit of all the stakeholders, authority wants everything to go in order and smooth, right? So authority would now ask you directly, just like your mother asked you directly who is honey, the authority is also going to ask you directly, why this inconsistency? Give me more information so that I can sort this out. You gave information, but one case can be that the information was satisfactory and the authorities are satisfied. Okay, this was the case, that's why I'm seeing this. Fine, the authority is satisfied. But if authority is not satisfied with your reply, then the authority would want to make further, I'm not using any term here, inspection, inquiry or investigation. What is it? Although let's say if there is a crime scene, what do police authorities do? They first inspect the scenario, right? The crime scene. They come, they just have a look at everything, what is it, how it is, then they make inquiries, and finally if required, investigation is carried out. At prima facie, you may come to a conclusion that no investigation is required. Investigation is the most in-depth manner, detailed, you can say, analysis of the situation. So investigation is something for a serious offense, you can say, when things are being carried out in fraudulent manner or anything like that, and you need proper investigation. Inspection and inquiry are not so much in-depth. Investigation is in-depth process, okay. But from your point of view of Companies Act, as soon as we read all the sections, section 206 covers both the cases of inspection as well as inquiry. In the initial sections, we will talk about inspection and inquiry, and after that maximum sections relate to investigation only. Okay, so investigation is actually more important concept in this particular chapter. However, inquiry holds a very nominal place, you can say, in this particular chapter. But as we go on to read the sections, at the end again we will discuss and we will come to the conclusion that what we have understood with these three terms and what are its different provisions. Okay, so now we'll start with the chapter. I hope you have got that basic idea and framework as to these three terms. Okay, great then. Section 206, the very first section, section 206, this my dear we are reading is the 14th chapter of Companies Act 2013, which actually covers section 206 to section 229. So there are these many sections that we have to study, all the small sections only. Companies, Inspection, Inquiry and Investigation Rules 2014. Okay, so this particular chapter is read with the relevant rules and comprises of these many sections and the chapter number, although that is all not so important. The first and the foremost thing that is important is to learn the provisions, and for learning the provisions we have charts for all the sections. Okay. So I don't think with this chart you will have absolutely any problem in revising, learning and scoring. So section 206. First of all, open your charts. You will be able to understand it better through charts. I'm going to explain you the whole process and then we will read section line by line so that we are able to analyze and present answers better in the examination. company has filed some document with ROC. Now, throughout Companies Act, we have read at so many places that company is required to file this, company is required to file that, company passes special resolution, file MGT 14, company has to file annual return, company has to file financial statements, company has to file this form, that form, director, this form, that form, so many forms. So often, there is a lot of information that actually we give to registrar of companies, right? It is only us who are giving the information, and there might be information which is already with the ROC. ROC has received it from some other source, or it exists with the ROC, or it's some past information, whatever it can be. So we have filed some document, or ROC already has some information, doesn't matter. The information is now with ROC. When ROC reads that information, there is some suspicion. ROC, when realizes, when reads it, when scrutinizes it, finds some inconsistency, some deficiency, and so the suspicion grows here. What do ROC do? What will ROC do? As I've told you, ROC is not satisfied with whatever document and all you have filed. Okay, there is suspicion. When there is suspicion, ROC will want more information, or ROC would want explanation from you. Just like your mom asked you who is Honey and wanted an explanation, like that ROC also. What is ROC? Registrar of Companies, right? ROC wants explanation from you. If you're able to satisfy ROC, great. But if not, ROC will take further step. So, to seek more information or explanation, ROC is going to send you a written notice. See, ROC is not a relative of ours that we have gone to meet ROC and ROC will say that this information is not matching. What is it, yaar? ROC is not going to say like that, just like our mom says, right? So, ROC and our communication is going to be written. ROC is going to send an official written notice to us that these are the information, just like an income tax. When prima facie, often a lot of information is required. Not even when the proper scrutiny 143(2) that is not going on, then also you require a lot of information. Often it is asked online only. So likewise, Registrar of Companies has sent us a written notice and asked us, this is the piece of information that we require, ROC requires from company's end. Okay. So ROC is going to send a written notice to the company. Company, its present and past officers are required to send information. Whenever we are receiving any official notice, is it not our duty to furnish that information? Of course, it is our duty. The question here is whose duty it is. It is company's duty, but company does not act on its own. Company has the representatives to carry out all the functions, right? So the company has directors, its officers, its employees and everyone. So anyone to whom such task is delegated, that is its directors, its officers, they are going to furnish information. Why have I written here past officers? Because Act has specified so. Act has specified so. Supposedly, this notice is received here. Notice received by company from ROC for information regarding contract with ABC Limited. Okay, and here contract was entered with ABC Limited, and here Mr. X, one of the directors, resigned. Okay, now ROC wants information regarding this particular contract. This information can be given by all the people who were present here. At the time when the contract was entered, at the time when the contract is carried out, all this period, Mr. X was also one of the person who were present during this period. Although today he is not a current employee of the company, today he is not the person who is working for the company, but at that particular point of time he was the employee, he was the director, he was working for the company. So he will definitely have that relevant information which ROC needs. So ROC can even send a notice to this particular director and he has to reply. It is his duty to furnish information. That is why it has been clearly specified that it is company's duty to furnish information. It's present all the officers as well as past officers. It is the duty of all these officers to send information, explanation, whatever is required by ROC within the time specified in notice. Notice is going to clearly say a reasonable time. No time limit has been specified in the Act. Notice may say that you are supposed to reply within 20 days. You are supposed to reply by or on or before such and such date. So you have to reply within that specified time. You may ask for extension if you have a justified reason, and some extension may be granted to you. So after the receipt of notice, there can be 3 cases. Reply was given within reasonable time, extension was taken and reply was given within extended time, or no reply was given in both these cases. No reply was given at all. So these are the 3 possibilities which may arise when written notice is received by ROC for seeking some information or explanation. If reply is received and reply is satisfactory, ROC doesn't need to do any further inspection, inquiry, investigation. First of all comes inspection, and then there may be inquiry, or inspection and inquiry can be 2 different things also. And lastly we have investigation. Okay, this particular section, this particular point that we are reading is all about inspection. Section 206 has some provisions relating to inquiry and some to inspection. We have divided into 2 different parts. So you can read here, power of ROC to call for information and inspect books. Okay, so this is about inspection. Then you will see power of ROC to call for information and conduct inquiries. Both are section 206 only. So one by one we are going to read both. Right. Now if the reply received from the company is satisfactory, ROC does not need to go for inspection. But if the reply is inadequate, that means we needed more information but we have provided less information, or it is unsatisfactory or no reply at all. See, no reply at all. Then ROC is going to record reasons and give a written order to company. What order? It is going to be the order for inspection. Order for inspection. To produce books of accounts and books and papers, you have read about books of accounts and books and papers. What are they? Books of accounts mean financial statements, balance sheet. P&L books and papers means all other relevant vouchers, documents, supportings, everything. Okay, so the whole set has to be inspected now. ROC is suspicious, is doubtful of what is wrong and what is right. ROC is unable to identify and judge, and believes and has strong grounds to believe that there is something wrong with the financials, with the books of accounts. So ROC wants all this information. So ROC wants you to produce complete set of books of accounts and papers at a prescribed time and place for inspection. If you know what income tax scrutiny is, you will very well able to analyze this particular situation also. After that, once the books and papers are produced, ROC is going to conduct inspection according to section 207. Now section 207 has the whole process of inspection as well as inquiry. Okay, so the procedure has been written in section 207. After inspection is carried out, ROC is going to prepare a report that this was our doubts, this is the information that we obtained, this is our conclusion. Okay, this is what we have concluded. So the complete report is going to be prepared and submitted to central government. Under section 208, again we will read it with proper recommendations, and after that central government may carry out investigation if it wants to. So investigation is at a later stage. Primary stage is inspection. You do not know whether you should investigate or not unless you have actually made proper prima facie inspection. Okay, so central government may also direct inspection and authority. All these parts we are going to study when we read about the section in detail. Okay, so finally our text. A lot of the text that has been written in the book is a part of Bare Act. Okay, so we have to analyze what is written, and section 206, power to call for information. Who has the power to call for information? Central government has the power to call for information. Why central government will call for information? To decide whether it wants to inspect or not, and if it wants to inspect, it can go for inspection, or it can conduct inquiries also. So inspect books and conduct inquiries, and for that particular purpose they can also call for information. Where on a scrutiny of any document filed, person has filed document with the registrar that is scrutinized, analyzed by ROC, and the registrar is of the opinion that further information or explanation or any further documents is necessary, who may? Registrar. Registrar may. That means it is at the discretion of registrar whether to call for more information or not. So even if registrar finds on scrutiny that more information is needed, yet registrar can ignore the same. So it is at the discretion of registrar. By a written notice required the company to furnish in writing. I told you ROC and the company, they are going to have that written communication only. So ROC has sent a written notice. We are also going to give a written reply. It is not going to be oral. Okay, so to furnish in writing the information or explanation, or if any documents are required to be produced, to produce such documents. Within what time period? Within such reasonable time as specified. That means Act is somehow giving a direction to ROC also to make sure that reasonable time is given to the company. That means ROC shouldn't furnish a notice to the company that reply within 1 hour. Even if our girlfriend messages us and asks us to meet within 1 hour, it is not possible, right? It is not possible, especially in metro cities like Bangalore, Delhi, right? It is not possible. Okay, so to furnish information to registrar within 1 hour will not be possible. So it has to be justified time, reasonable time, 10 days, 15 days, considering the fact that what information you are seeking. If it is just a normal bank statement, maybe you can definitely write 10 days. 10 days is quite sufficient time to walk into the bank and get that bank statement and furnish the same, right? So depending upon the piece of information that you require, ROC must decide what should be the reasonable time, and accordingly that reasonable time should be specified in the notice. When the notice is received by the company, it is going to be the duty of the company and all the concerned officers to give that information and explanation to the best of their knowledge and power. To the best of their knowledge. See, if there is any authority and that authority walks up to me and asks me about Mr. X, do you know the deal with Mr. X? I know very little information. It might be correct, it might be incorrect. But whatever information I know, that only I will be able to produce, right? That only I will be able to tell. Just like in a police investigation, in a police inspection, whenever any crime scene or anything is inspected, the police is going to go to various places, talk to different people and try to gain that information. Not all piece of information might be correct, but what is important as good citizens, it is important that whatever you believe and know it to be true, that you should give. Okay, that means if you know something else and you're giving some other information, that is not your duty. You should tell to the best of your knowledge. That is important. You should tell the truth. That is not written, but you should tell the best of your knowledge, because we cannot say who knows the truth and who doesn't know the truth. It is very correctly said and aptly said that every story has three sides: one mine, one yours, and the third the truth. Okay, so nobody knows the truth, but you give your best, I will give my best, right? To produce the documents to registrar within the time specified or extended. Okay, provided that where such information or explanation relates to any past period, the officers who had been in employment, if so called upon by the registrar, through a notice served on them in writing, shall also furnish information. Okay, so I told you this particular point also. Now, if no information is furnished or explanation is furnished within the time, or if the registrar after examining the documents is of the opinion that the furnished information is inadequate, or if the registrar is satisfied on the scrutiny that an unsatisfactory state of affairs exists and your financials do not disclose the full and fair statement of information required. So firstly, reply is not received. Secondly, whatever reply is received is inadequate. Thirdly, after scrutiny, registrar realized that there is unsatisfactory state of affairs, or whatever information that you have given does not disclose full and fair statement, so it is unsatisfactory. So in these three cases, registrar is going to give another written notice and call on the company for producing all their books of accounts, papers, explanations for his inspection. So now the inspection has begun. Till now it was only obtaining some information to decide whether inspection should be carried out, or it is just a regular some default or something like that. Okay, so now inspection is going to start. Where do you have to produce these books of accounts, papers and explanation? At such time and place as may be specified in the notice. Before serving any notice, the registrar is going to record reasons in writing. I think I clearly specified this. Yeah, record reasons, and then it is going to give this order. Order of inquiry, right now I am leaving because that we will be doing afterwards. See, central government may, if satisfied that the circumstances so warrant, I have written here, central government may also direct inspection, right? So central government may, if it is satisfied that there are circumstances, it may also direct inspection of books and papers of a company by an inspector. See, till now whatever provision we read, there was no mention of the term inspector. Inspection, inquiry and investigation, all three are carried out by the inspector only. Inspector can be of different grades. Maybe the person who is carrying out investigation has more knowledge or has less knowledge, but the term used for carrying out these is the same, inspector. But so far in the section, what we have seen that registrar himself is carrying out the inspection. He is not appointing someone else to carry out the inspection. Right, but now here in this particular point, we are seeing that central government, if it thinks fit, may appoint some inspector, and that inspector is going to carry out inspection. So central government has the supreme power to direct inspection and to even appoint inspector. Now many a times it happens that there are certain types of special types of companies. Supposedly there is a banking company in which there is this problem, and central government feels that believes or is of the opinion that such companies books and papers, they are not representing a very true picture, and we find some problem here. So central government may want to direct inspection, but if central government appoints some normal inspector, he will not be able to identify that minute details which relates to a banking company, right? So central government doesn't want any inspector to inspect the books of accounts of a banking company, but wants some special authority to do so. Just like if there is a inspection of some specific area, if I want to go to a doctor, if I have any problem which can be solved by any doctor, I'm going to visit a general physician. But when I have a specific problem, supposedly there is any skin problem, so I am going to visit a dermatologist only. Why? Because I know that particular person will be able to understand my problem. Likewise, when the things are general and central government believes that it can be done by the inspector, central government is going to appoint the inspector. But at times it happens that some special authority can actually deal with the situation. If it is an insurance company, you have IDA, right? So if you have banking company, you have banking authorities. Okay, so the ones who govern. So there can be some different departments, some different authorities to which central government may assign such inspection, may direct such inspection. Okay, so central government may also direct inspection, appoint inspector, or authorize any statutory authority for the same. If the company fails to furnish information or produce any document, then company and every officer who is in default is going to be liable to a fine, maximum 1 lakh, and if your default continues, additional fine 500 per day after the first, during which failure continues. So penalty is something that you need to learn. And now we are left with the part of inquiry. That is subsection 4. I hope you have understood the part of inspection, that is the whole process, how it is carried on. After the inspection is directed, central government, if it has appointed inspector, then inspector is going to carry out the inspection. Otherwise, registrar is going to carry out the inspection. How they are going to carry out the inspection? The procedure is given in section 207. After they have carried out the inspection, they have to give a report to central government. The report part is given in section 208, and once they have submitted the report, central government decides whether to conduct further investigation is needed or it is not needed. Okay, so that is covered in investigation part. So I hope starting from the suspicion part till the inspection part, you have understood all the provision. Thank you.